my learned friend Firoz Norji, Senior Counsel Amos Wako, Attorney General Emeritus, Senior Counsel Okongo Mugeni, and my learned friends Mr. Otiende Amolo, Mr. Paul Mwangi, Mr. Professor Mtaha Kangu, Professor Ben Sihanya, Mr. TJ Kajuang, Mr. Peter Kaluma, Honorable Millie Odhiambo, Ms. Julie Soweto, Norman Magaya, Dan Manzo, Anthony Olwach, Willie Sotieno, Jackson Awele, Madeline Murumba, Celestine Opio, Mr. Maumo, Judy Olo, Arnold Oginga, and Kevin Wakwaya. Those are the appearances for the petitioners.
Thank you, Mr. Orengo. Mr. Mwite.
The first and second respondents are represented by the same team of lawyers whose names you have on record already. I think in the interest of saving time.
No, read them out. Read them out.
There's a list. My Lord, the first and second respondents are represented by myself with Kamau Karoli, Senior Counsel Luce Kaboni, Professor PLO Lumumba, Cyprian Wekesa, Mr. Sisule, Diego, Paul Ilan, Eric Gumbo, Mr. Mukele, and Mr. Morogo. Isa has gone for prayers. Isa Mansour.
Thank you.
Yes, my Lord Chief Justice and Judge of the Supreme Court, for the third respondent, my name is Ahmed Nasir. I'm appearing with my learned friends Ken Ogeto, Evans Monari, Katwa Keegan. Fred and Katia will join us later, my Lord.
Thank you, Mr. Nasir. Please raise your voice. You are far off.
Your Lordship, the Chief Justice.
Just a minute. You get the microphone.
Thank you very much. Your Lordship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, Your Lordships and my lady, Harrison Kinyanjui, up here for Professor Michael Wainaina Mwaura, an independent candidate, first interested party.
Thank you, Mr. Kinyanjui.
May it please the court. My name is Elias Mutuma. I appear alongside Mr. Ignatius Mohatia for the second interested party, Dr. Ikuru Court. Thank you.
Thank you.
A very good morning, my Lord Chief Justice and judges of the Supreme Court. It is Eid and it is a happy day. I am honored to introduce Mr. Kaumba Samuel, who holds brief for the first amicus curiae, the Honorable the Attorney General. My name is Stephen Mwenesi. For the second amicus, the Law Society of Kenya, Stephen Mwenesi, I appear with Mr. Omwanza Ombati in that regard. Thank you.
Thank you very much, Counsel. First and foremost, as you can see, we are 6. I'm sure you are aware that the Honorable Justice Ibrahim was taken ill. He is in hospital. I have spoken to him this morning. He's doing very well. And by the grace of God, he should be discharged in a few days. And in 2013, the court read the decision of the court without a full judgment. That was not received very well. And the expectations were that this morning we should read a full judgment. You know, we have had long hearings. Some of them have gone to late at night. We concluded the hearing on Tuesday, well after 9 o'clock. I want to state that given the tons of material placed before us, it was not humanly possible to go through that record and write a reasoned and well-considered judgment. That we will do on a later date. So I'm sorry we have to disappoint those who expected a full judgment today, and I believe to a large extent the nation. But you will understand that given the timelines we have, if we don't deliver a judgment today, we will cause a constitutional crisis. So what we have this morning is a determination of the court. Now, before I read that determination, I want to say this. The greatness of a nation lies in its fidelity to its constitution and a strict adherence to the rule of law. And above all, the fear of God. Having said that, I would now like to read the determination of the court. The hearing of this petition was concluded on Tuesday, 29th August 2017, well after 9 p.m. The judges thereafter retreated to deliberate on the various issues for determination as crafted by the court. The issues were, number one, whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the law relating to elections. Number two, whether there were irregularities and illegalities committed in the conduct of the 2017 presidential election. Number three, if there were irregularities and illegalities, what was their impact, if any, on the integrity of the election? Number four, what consequential orders, declarations, and reliefs should the court grant, if any? Having carefully considered the above issues, the following is the majority decision of the court with two judges, the Honorable Justice Ojuang and the Honorable Justice Ndungu dissenting. As to whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the law relating to elections, upon considering inter alia Articles 10, 38, 81, and 86 of the Constitution, as well as sections 39(1)(c), 44, and 44A and 83 of the Elections Act. The decision of the court is that the first respondent failed, neglected, or refused to conduct the presidential election in a manner consistent with the dictates of the Constitution, and inter alia, the Elections Act, Chapter 7 of the laws of Kenya. Number 2, as to whether there were irregularities and illegalities committed in the conduct of the 2017 presidential elections, the court was satisfied that the first respondent committed irregularities and illegalities inter alia in the transmission of results, particulars, and the substance of which will be given in the detailed and reasoned judgment of the court. The court, however, found no evidence of misconduct on the part of the third respondent. Number 3, as to whether the illegalities and the irregularities affected the integrity of the election, the court was satisfied that they did, and thereby impugning the integrity of the entire presidential election. Before I proceed, I would now like to allow my two colleagues who are dissenting to read their views before we read the final orders of the court, and in this regard I will request the Honorable Justice Njoki to read.
This is a summarized dissenting opinion from myself. The court has rendered its judgment by a majority. I am, however, of a different opinion. At the heart of democracy are the people who will constitute the strand of governance that we have chosen as a country. On the 8th of August, 2017, millions of Kenyans from all walks of life yielded to the call of democracy and queued for many hours to fulfill their duty to our republic by delegating their sovereign power to their democratically elected representatives. This was an exercise that was hailed by many regional and international observers as largely free, fair, credible, and peaceful. That duty stands sacred and is only to be upset if there is any compelling reason to do so. That reason must affect the outcome of the election. The election was managed by the first respondent, chaired by the second respondent, who were assisted by hundreds of others to execute the mandate of the Commission under Article 88 of the Constitution. At the end of the process, the second respondent, in accordance with Article 138(10) of the Constitution, declared the result of the election. Having received more than half of all the votes cast in the election, and at least 25% of votes cast in each of more than half of the counties, the third respondent was declared the President-elect. As the Chief Justice has stated, the case revolves around three fundamental questions. One, I want to repeat them. One, whether the election was conducted in accordance with the Constitution and the law. Two, whether there were irregularities and illegalities committed during the conduct of the election. And three, if there were irregularities and illegalities, what was the integrity of the election? In answer to these three issues, my opinion is that the election was conducted in accordance with the Constitution of the law. And in fact, this first and second respondents, to my satisfaction, demonstrated that they had adhered to the directions given by the Court of Appeal in the case of the Independent and Electoral Boundaries Commission versus Maina Kiai, where the Court of Appeal cautioned, and I agree with them, that the results declared at the polling station are final. In fact, the polling station is at the heart of any election. It is what happens there that is to be assessed, and that is why its outcome is final. In any election, the ordinary Kenyan voter will ask themselves the following questions. 1. Was there a problem with the registration of voters? 2. Were voters properly identified at the polling station? 3. Were voters allowed to cast their ballots peacefully and within good time? 4. Were the votes cast, counted, declared, and verified at the polling station to the satisfaction of all parties? If the answer to all these questions is in the affirmative, then the election has been conducted properly. The petitioners, in my view, did not present any material evidence to the standard required to upset the results returned to the National Tallying Center by the presiding officers in forms